the foreign minister is on record and he's come out publicly to state the position of the government. And the foreign minister is indicated that government does not intend to present this Memorandum of Understanding to Parliament for ratification. And that only when, in his words, the MoU is elevated to the level of an agreement before the agreement to be laid before Parliament for ratification or otherwise. But as you know, the framers of our Constitution, specifically Article 75, were very deliberate. And the provision of Article 75 is absolutely unambiguous, which says that treaties or agreements or whatever arrangements the government of Ghana gets into which imposes obligations on the Republic of Ghana requires parliamentary ratification. And we've had multiple occasions where the Supreme Court has had the opportunity to make a firm and clear pronouncement on the remits or ramifications of Article 75, where the Supreme Court is stated clearly that even note verbals, which is exchange of correspondence, administrative exchange of correspondence, will require parliamentary ratification. And I want to believe that the rationale behind Article 75 is just so that the people's representatives in the course of the tenure of a government get the opportunity to scrutinize such agreement, and so that we all will be on the same page and matters will be transparent in the national interest of Ghana. And so this is why we're making the call that the government should lay the MoU before Parliament for ratification.
But is there a need for them to halt what they are doing before they come for ratification?
Well, to the extent that the minister says, the Honorable Minister says, they do not intend to lay the MoU before Parliament for ratification, and that they will do so only when it's elevated to the level of an agreement. It presupposes that, for example, if it's not elevated to an agreement, the MoU will be operationalized, and the implementation of the MoU will take effect as it is now, without it being laid before Parliament. And several questions have been asked by well-meaning Ghanaians, by civil society, by media about the terms of this MoU. What are the obligations on Ghana? What are the implications for our sovereignty, for example? What are the implications for our national security? What is going to be in it for Ghana? How is Ghana going to be seen on the international stage as, for example, aiding the Trump administration's policy on immigration, which has become a controversial policy where the African Union has had an occasion to make a pronouncement on it, and to be able to adhere to the HO cherished principles of an accountable democracy and governance. It is just proper that the government lays the MoU before Parliament. So it's absolutely transparent. So Parliament will get the opportunity to scrutinize this and ratify it or otherwise.
How do you respond to critics who say that your call might be duplicitous in the sense that you're looking at some other international treaties that we're already signatories to? For instance, the Convention on torture, which provides for the means by which you can move a deportee to a third state. Article 3 of that convention talks about the fact that once there's no immediate danger to the deportees, of course that agreement can be enforced by a third state. So are we not already signatories to that party? Why do we need another ratification then?
Well, that's a very good question, Blessed. And I think then the point also that the question that will be asked is that why then have an MoU? Why not proceed on the basis of this treaty? And why not proceed on the basis of the provisions of this treaty and go ahead to admit third party deportees into our country?
Right.
You know, I've just been trying to explain that there are, in my view, my respectful view, very cogent reasons in why the framers of our Constitution provided for this kind of procedure within the confines of Article 75. You know, when you get into such agreements with foreign countries, other states, the requirement for scrutiny and transparency is absolutely important. You recall, for example, that the Kufuor administration got into a defense cooperation agreement with the United States of America. That agreement was laid before Parliament and it was scrutinized, and the terms of the agreement were made known through the people's representatives, i.e. the legislature, to the country, and the agreement was ratified. And when you take the process, when you adhere to the procedure of Article 75, you lay all kinds of questions to rest, and then it becomes absolutely transparent. And as I say, in this particular case, we're dealing with a subject matter which is turned out to be very controversial. In fact, some of these deportees have even mounted lawsuits in Ghanaian court, challenging the legal basis for their detention and for their deportation, and even making allegations of breaches of their fundamental human rights and so on and so forth. So I think it's even in the interest of the government for the government to come through the route of Article 75 and make matters absolutely transparent.